Well, former President Jacob Zuma has suffered another legal blow in the KwaZulu-Natal High Court after a full bench set aside his private prosecution of advocate Billy Downer and News 24 legal journalist Karyn Maughan. Zuma instituted the private prosecution in September, claiming that his private medical information was leaked to Maughan. The letter by a military doctor was attached to documents which were submitted to court in Zuma's arms deal corruption trial. Now, the court order says the following. That the summons for the purpose of instituting a private prosecution against Maughan and Downer, the applicants, is to be set aside. Zuma, as the respondent in this matter, is now interdicted from reinstituting, proceeding with, or from taking any further steps pursuant to the private prosecution. And the costs of the application are to be paid by Zuma, who is the respondent in the matter. So we have a little more for you on the story, and here is SABC News reporter Simpiwe Makanya.
Well, indeed, the Pietermaritzburg High Court earlier today making that all-important ruling, which basically sets aside the private prosecution bid, by former President Jacob Zuma to legal journalist Karyn Maughan, as well as state prosecutor advocate Billy Downer. But let us now engage Mr. Mpumelelo Zigalala from Zigalala Attorneys, who has been following this particular matter closely. Mr. Zigalala, thank you very much for your time. Just your overall reaction in terms of this particular judgment?
Well, it's difficult to make a conclusive one because about minus 58 pages that we need to go through in order to get the reasons for the judgment. But the judgment was clear in terms of saying agency has been granted in favor of the applicants, which is advocate Billy Downer and Ms. Karyn Maughan. And secondly, when you look at the merits, the court coming to the conclusion that there's no private prosecution which is supposed to take place, that's setting aside even the summons in which the former president is relying on. And they can't, or he can't use the summons again in terms of furthering any type of further prosecution that has to be there. Another notable thing is the type of cost order which was given, which is on an attorney and on client cost scale, which is the highest cost order that you can get, usually given to individuals in which you are saying, I want to punish you a bit for the manner in which either you've engaged in these proceedings or the frivolousness of the proceedings that you have brought in this matter. So it's one of the things that when you look into the judgment, you will have to find certain points in which the court will make very important comments as to why that particular judgment was granted. As I scanned through it, there was an issue which was raised in terms of a non-tailor-made or non-specific made prosecution certificate which is being relied on, especially against Ms. Karyn Maughan, in terms of saying you can't have a blanket prosecution, a non-prosecution certificate, and use that to then say, I'm going to prosecute anyone who's anyone on this matter just because their name happens to appear within my radar. But certainly the court will make a determination based on that in detail in its judgment.
What sort of impacts will this judgment have in the criminal matter that is before this court?
Strictly speaking, shouldn't have none. But if you are coming back or focusing on what was supposed to happen in August, if I'm not mistaken, it may be moot, because if the summons are set aside and there's no appeal that has been filed by the former president, it means why are we here to discuss a matter in which the circumstances or the facts have changed? Or if there's a leave to appeal that has been granted, the court may decide, okay, I want to hear you because the status quo has remained the same. I'm not going to delay this matter any further. Or the court may decide, or even the parties may decide that let's leave all those particular discussions on the side. We are withdrawing our application in which we are going to file in August. Let's rather determine on which days the first witness is going to go into the witness box and be able to deliver evidence in the case of S versus Zuma.
We had the court earlier making remarks in terms of the nolle prosequi certificate. What does that mean going forward?
It means the manner in which this court has determined it. Remember, it's a high court. So whatever interpretation that there is, the other courts may even think of, let's adopt the same type of interpretation if it fits into what we are thinking about. Remember, our judges are independent. They only think on their own and what they think is in the best interest in what the law actually says. But take note of what is happening in the Gauteng division, where the former president is again defending a matter by the current president. You may seem to get an indication of how the courts or the law seems to view these null prosecuted certificates, which are not suspect specific or name specific, and the validity of those certificates, you may find that the court may rule in the president's favor and say, well, the certificate is defective. The manner in which you've engaged in this particular manner is not a manner in which the law actually prescribed. But what is going to assist is that with this number of cases going into our courts where null prosecuted certificates and the private prosecution is being determined, it may put us in a better legal position of understanding how should one conduct a valid private prosecution, what are the summons that needs to be there, how the null prosecution certificate ought to be drafted, and when is it legal for you to do so without stifling any media freedom.
What are the prospects of success in terms of if the former president, in fact, does appeal this particular ruling?
Well, it would depend on the manner in which the interpretation of the judges has gone about, either in terms of the law or in terms of the facts which were then considered. What is of concern, which maybe later I'll get a much better understanding, is in what instances do you then or how do you raise a certain concern in which you might have, in which when you allege that a prosecutor has breached the NPA Act and you want to act upon that. When the NPA then comes back and say, we are not going to prosecute this matter, you have no other avenue rather than to go the private prosecution route or to institute those proceedings on your own. In this case, Advocate Billy Downer did have another prosecutor certificate which was tailor-made for him. So on that basis, maybe after the better understanding of the judgment, one will come to perfect reasoning as to why the court decided it in that manner. But it's one of those things in which the court ought to decide. And if it has not been dealt with by that judgment, then the SCA definitely will have much more stronger grounds in terms of saying, let me listen to the matter, let me listen to the appeal, so that I can be able to make a determination as to what is wrong and what is right in terms of the conduct of a prosecutor. And the prosecutor will then engage in an act that contravenes the NPA Act, how to go about in terms of disciplining that prosecutor.
Mr. Zikalala, as always, thank you very much for your time.
Thank you very much for hosting.
That's Mr. Mpumelelo Zikalala from Zikalala Attorneys. It's back to you in Johannesburg.